Hello entrepreneurs, it's Michael Mort with Argent Place Law, the law firm for entrepreneurs. In a recent post, I mentioned that there's been some changes in Virginia law that affect independent contractors and hiring independent contractors. I quoted from a portion of the law by saying that if a person, including a company, pays an individual, then it's assumed that the individual is an employee of that person and the person is the employer of the individual. There is more to the sentence. Let me finish the sentence in the law. It says that is true unless it is shown that the individual is an independent contractor as determined under the Internal Revenue Service guidelines. It goes on to say, what does that mean, the Internal Revenue Service guidelines? That means the most recent version of the guidelines published by the Internal Revenue Service for evaluating independent contractor status. So there's a big test at the IRS website for all the things you have to think about to determine whether or not a person is an independent contractor or an employee. But there's a wrinkle. I told you that you should hire only companies, not individuals, and that will take you out of the rubric of this law. But how is an individual defined? It's not defined in Virginia code. As I told you, it's listed among other things. When you talk about a person could be an individual, it could be an LLC, it could be a corporation, etc. Here's the wrinkle. The IRS ignores LLCs that are owned by a single person. A single member LLC is disregarded at the IRS for purposes of taxes. A single member LLC is treated as if that is the same as the individual. Now, I'm not saying this is part of the law, but I can imagine a zealous lawyer and a compliant court saying, you know, we might as well resort to the definition that the IRS uses for what an individual is when we determine whether or not this company protects you from this Virginia law. So what would be the way around this? Well, when you make your single member LLC, the default is that you're treated as a disregarded entity, but you can elect to be taxed as an S Corp or a C Corp. That would completely make you, in the eyes of the IRS, be a corporation of either an S Corp or a C Corp. So, I'm not saying this would happen, but in the case of, as I said, a zealous lawyer and a compliant judge, it might behoove you to make that tax election. You're a single member LLC, either bring on a partner, so you're treated as a partnership, might be your spouse, might be a close friend, or still stay a single member LLC, but elect to be taxed as an S Corp or a C Corp. In fact, most of our single member LLCs, when we form them, we recommend our clients submit the election to be taxed as an S Corp. So that's one wrinkle that I think you should consider just for the full measure of protection, to be treated as a company and taken out of the rubric of the Virginia law that applies to individuals who want to be treated as independent contractors. I know that's a lot to think about, and give us a call if you want more information. I'm Michael Mort with Argent Place Law, the law firm for entrepreneurs. We're here looking out for you. Thanks for listening.